call this work session on marijuana land use to order, and I will begin by going around in introduction to the individuals sitting at the table here. Is that in agreement, Mr.
Tim Steele, somebody's been on
Amanda.
Lee Peterson.
Amy Bobby,
Bernie Hall.
Phil Evans. Patrick Flynn.
Julia Tuckerton of council,
Todd Sherwood, Assistant Municipal Attorney.
Erica McConnell,
Bill Falsey, Municipal Attorney.
Good. And who do we have on the phone?
Jennifer Johnston with a bad connection.
With a bad connection. Okay, Jennifer. We'll hope you can work that out. We are waiting. I'm not going to wait. We're going to go ahead and move into this work session. But we got another document coming down. What we got before is this licensing, which is for our second work session at noon today. And the others are running. They had to get one more tree cut down quickly, process the paper, and print it because they're both very large documents. But as soon as the others come out of the printer, we'll have those available for us. I wanted to begin the meeting with some comments today so I can kind of set the situation here for particularly for the assembly and of course everyone that's here to listen. What we're going to have before us today are two good documents to work with. And probably in this particular legislation before us, as individual members, probably going to require that maybe work a little harder than we normally do, although all of you always get the job done. But in dealing with marijuana, we're in brand new territory, and we're also dealing with a situation where in the initiative, the indication was kind of like we will treat this like alcohol. And I believe that the state marijuana control board has done a pretty good job of doing that. And they mirrored a lot of what happened in regards to alcohol in the state. But the thing that makes this uniquely different is with the federal government, alcohol is a legal substance. Marijuana is not legal by the federal law. So we're in a unique situation here. So some of the things that you're going to see as we work our way into these documents, we're going to appear to even conflict with the state. And I'm going to let Mr. Falsey walk you through all of this here in a bit. There's not a lot of points there, but what we do know are there are some issues that the federal government is weighing in on in Colorado that they're making specific issues of. So we're trying to look ahead and address that. Alaska is unique, and that's part of what was handled to a degree, I think, with the Marijuana Control Board in some of the separations that were handled. And I don't disagree with that statement that Alaska is unique, but not necessarily so much Anchorage. We are a large metropolitan area, and things that would be an issue in Barrow wouldn't be an issue here. So where we went with everything that we've done here is try to look at it under the scenario that what we want to do is when we start working on this document, we felt that it was better to kind of be all-inclusive so that some of these issues that the body may want to take out, we felt it was better to remove it than to write it on the floor. So we're going to be very open and fluid in what we do here, so much so to the point that Mr. Trainee has scheduled another work session next Friday on these both of these, and he has scheduled a special assembly meeting And that's not a work session, that's an actual meeting of the Assembly on February the 4th,
Starts at 6 and ends at 11.
starting at 6, ends at 11 in the Resac Library. Specifically, so these are the only two items that are going to be on the agenda that evening. We anticipate that there's going to be some rolling up our sleeves and doing work in what we want to do, because we're already receiving input from Girdwood that, you know, with the way you've written this, everything's too close. We don't have zoning that you're looking at, and we know, we are aware of that. So we're going to figure out a way to work our way through it. But I felt the best way to do that was to do it as a body of the whole, so we're all up to speed on specifically what we're addressing. So with that said, with our land use, and Ms. Dombowski, I particularly want to thank you. It's greatly appreciated that we were able to move that document the way that we did. And believe it or not, ladies and gentlemen, this is really the way municipal ordinances and codes that when they're introduced should work. Good work is put together drafting it, and then that final document is done with the input of all 11 people when it comes before us in work sessions, as well as when we actually get into our meetings. So the ideal thing that I encourage all of my fellow assembly members is today we want to engage in conversation on this. Please do your work on it. And next Friday when we meet, it would really be great if you've got amendments to get us some rough drafts on those, so we're able to work on those, and we're doing a lot of that actually on the night of the meeting, or at least that the rest of us have the ability to read it and kind of be ready when we show up to the actual work. Amy, I'd like to give you an opportunity to make any comments you'd like in regards to the land use ordinance. And of course, we've got Erica. Thank you for what you've done, as well as Mr. Falsey, our municipal attorney here, and they will spend most of the time walking through the document. So.
I think you covered it well. I just, want to reiterate what you said. I mean, this was a monstrous feat to accomplish as efficiently, I think, as we have done. It may not seem it to some, but considering the monumental task we had in front of us, I just want to say thank you. But I also want to thank the Planning and Zoning Commission, because we know they've already had their public hearing on this item. They've taken a lot of time and effort in considering it and some of the issues that were raised. So I think they shouldn't be left out of the mix too. I know they've scheduled extra meetings just to deal with these issues too. So I think everybody's doing the best they can with what we have. Last night it came up in one of my community council meetings, and we recognize the documents at this point maybe not perfect, and we also recognize there's things that maybe we haven't considered. So I think public comment on what's before us is still very valuable, because this is a community effort, and in order to get it right, it's going to take all of us to critique it and make suggestions.
Thank you. And you're absolutely correct. I, too, am very appreciative of what Planning and Zoning did in giving special consideration to this, to give it the timely hearing so that we're not delayed. With that, Erica, would you like to lead, or Mr. Falsey, whichever one of you, flip a coin?
Maybe I'll start by saying I'm going to turn it over to Eric. But a little introduction is just to say, for everyone's benefit, that we have scheduled today back-to-back work sessions. We're starting first with the land use planning ordinance, and we're going to switch to the dual licensing ordinance later this afternoon. So as we look at AO 2016-3S, which I think we have copies either on or on their way.
There's one in your packet too. If you haven't picked your packet, it's in your packet.
They're on the way down.
On the way. This is the land use planning ordinance. It deals with some aspects of marijuana regulation which are not addressed at all in the state marijuana control board's regulations, in particular in what local zoning districts should the marijuana establishments be permitted. To review the bidding, there are 4 flavors of marijuana establishments in Route 2 and in the state regulations. There are the cultivation facilities, the manufacturing facilities, the testing facilities, and the retail facilities. Where those should go are each addressed in this, along with the second issue, and most related issue, of how far removed from certain protected land uses like schools and churches and other things should those 4 types of marijuana establishments be. This ordinance also addresses the process by which you can apply for a special land use permit for marijuana, addresses the who's, the how's, and certain approval criteria, some of which have gathered some public interest, one of which involves an industrial hygienist certification. We're happy to discuss that. So I think, as I understand it, the 3 items that may be of greatest interest to the public and assembly in this draft are the zones, the separations, and some of the approval criteria. But I'll let Erica do a more fulsome introduction, and it might be helpful to review the bidding because this is now, as Assemblymember Navosky said, an ordinance that has already gone through some substantial public hearing in the Planning and Zoning Commission. We had some great units that have been through
I don't know if there's a point to reviewing the original ordinance or just kind of start with the S version and walk through the changes that the Planning and Zoning Commission suggested. As Mr. Paul stated, this does establish the zoning districts in which these different types of facilities are allowed, the new specific standards that they have to meet, which includes separation distances and the approval processes. All types of special land use permits for marijuana, which every facility needs, come to the Assembly for approval as the Assembly desired, and we had worked out in earlier meetings. So some of the significant changes that the Planning and Zoning Commission recommended to you, I'll just kind of walk through in order in the ordinance, although it's not necessarily in order of significance or importance. And then after I do that, I'm going to just talk briefly about the maps that are on the wall. So, and I think we don't have copies yet. So they're coming.
I got one.
Okay, well, maybe I'll go backwards and start talking about the maps, and then hopefully by then
We can do that, but the reality is, Erica, if we're not trying to follow along with something we're reading while you're talking, we'll get a lot more out of it if we listen to you talk.
That's true. Okay. So we on the wall over here, there's maps of the Anchorage Bowl, and on the wall over there, there's maps of TDF Eagle River. I also do have maps of Birdwood, but ran out of space to put those up, so I'd be happy to pull those out should anyone desire to see them. There are 4 drafts of each map. The first draft, which is on the right of each series, shows the separation distance from protected land uses as proposed in the original draft of the ordinance. You may recall that when the Assembly Committee met and talked, we brought forward some significant questions for you to answer, some major policy issues. There were a number of protected land uses that were identified by the committee to have separation distances from, and so those were what were drafted in the original ordinance, and that's expressed in draft 1. The Planning and Zoning Commission, after they took public testimony, was concerned that having that many protected land uses was inhibiting too many, not providing enough locations for potential businesses, and so they wanted to see what the map would look like if there was just protected land uses as identified by state regulation. So map 2 shows just what the state requires. Between the Planning and Zoning Commission's public hearing and when they actually deliberated, the staff learned more about the federal drug-free zones. There's a difference between the Alaska drug-free zone and the federal drug-free zone, and I'm sure Mr. Halsey and other attorneys in the room can talk more extensively about that, but the Alaska drug-free zone is 500 feet from school grounds at or within 500 feet of a recreational or youth center or on a school bus. That's the Alaska drug-free zone. However, the federal drug-free zone applies to, I'm quoting, within 1,000 feet of the real property comprising a public or private elementary, vocational, or secondary school, or a public or private college, junior college, or university, or a playground, or housing facility owned by a public housing authority, or within 100 feet of a public or private youth center, public swimming pool, or video arcade facility. So we also created draft map number 3, which showed the combination of the state regulations of protected land uses and their separation distances and the federal drug-free zones. Maps 1, 2, and 3 were all based on the zoning districts as proposed to be allowed in the original draft. The other thing that the Planning and Zoning Commission recommended was to remove the ability to have retail stores in the B1A and the B1B districts. These are our small neighborhood commercial districts. We always use the Fire Island Bakery area as an example. That's a B1A district. It's right in the middle of the neighborhood. There's other examples, but the commission felt that it was inappropriate at this time to have retail stores tucked within those small neighborhood districts. So they recommended removing the B1A and the B1B as a location where you could have retail stores. So draft 4 of these maps shows the separation distances as recommended by the Planning and Zoning Commission and as expressed in the S version. So the B1A and the B1B districts have been removed from those maps. But they still show the state and the federal drug-free zones. I do want to give a caveat that, the planning department doesn't keep records of things like video arcades. So, we've done our best with the data that goes into it, but we do urge people not to make decisions based on these maps. It's the best we're able to do at this time, and it's to give the assembly a sense of policy decisions. But for anybody who is looking to open an establishment, we do encourage them to walk or drive around their proposed location to, investigate what's actually on the ground, because potentially there are errors. You'll see that, map 3 doesn't have Chuck E. Cheese on it because nobody thought, oh yeah, Chuck E. Cheese is a video arcade facility, and so that I think got added to draft 4. It's supposed to get added to draft 4. So again, there can be errors in there. Still no drafts. All right, well, I'll just start walking through the other recommendations of the Planning and Zoning Commission.
I'm sorry, Mr. Kent?
Yeah, Erica, before you go on, just, I think what I am hearing from you is if I see color on that map and not white, it's an excluded zone. Is that more or less correct?
The dark red is in draft 4 B3 zoning, and in the other drafts commercial zoning, that is not covered by a buffer. And the gray is industrial zoning that is not covered by a buffer. The buffer is in brown, and it's kind of the bubbles around the various identified uses.
So if it's brown or blue, no. If it's gray or red, maybe.
Yes.
Thank you.
Except for J Bear.
Right.
J Bear's gray, a very
Yes.
large gray area, and I'm pretty much confident they're going to stay down.
Yeah. I think that's just a standard color for the military bases. Okay. So. Okay. Community notice. That's something that's been a big issue, and particularly a concern of the community councils. I've been out to several, and they always talk about making sure that they're kept in the loop. So one of the things that is required of anybody applying for a marijuana license and land use approval is to hold a community meeting before they make their application. The Title 21 says that they shall use the community council as the community meeting unless there's some valid reason why they can't use the community council. We do have situations with many councils not meeting in the summer, and there's at least one council I know of that's inactive, although I don't think it has any commercial areas in it. So there were some councils that were concerned and said, well, if an applicant chooses or has to hold their own community meeting.
Here, Barbara, could we get some of those up here? Thank you. Yeah, there's none of it.
This is licensing.
No, we're looking for land use.
I'm sorry.
Okay.
Sorry, there's more coming. Amanda said every printer in the city is printing.
I'm sorry, Eric.
That's okay. So the community council wanted to be assured that if for some reason the applicant had to hold a community meeting that was not at the community council, that the community council would be notified of that. So there's a proposed amendment on page 3 of the draft that says if for some reason the applicant does hold a separate community meeting, they have to include the community council in the notice that they also send to the residents and property owners within 5 feet. So that was and that'll count for all different kinds of applications where a community meeting is required. So that was a good amendment. On pages 12 and 13, you'll see the changes to the separation from protected land uses that I've already discussed. So there were changes there. The commission recommended being a little bit more flexible about where various facilities were allowed. Originally, we had proposed that cultivation and manufacturing only be allowed in industrial districts and sales only be allowed in commercial districts. There was a lot of discussion and certainly some testimony about being able to co-locate, cultivation and sales or manufacturing and sales. So the commission recommended that sales also be allowed in the I-1 districts as a standalone business so that you could have sales in B3 or I-1, and that if a sales facility is co-located, so together with a cultivation or a manufacturing business, it could also be allowed in the I-2 district. We felt it was important to make sure that it was co-located there because standalone retail is not allowed in the any other type of standalone retail is not allowed in the I-2 district. But this would kind of be along the lines of a, sort of an accessory. And it wouldn't be an accessory use, but you could kind of think of it that way, that you have your cultivation or your manufacturing in the I-2 and then also a store associated. Just to make sure there's no confusion, these would be separate licenses and separate land use approvals. They would have separate licensed areas, but they would be just right next to each other. There'd be some sort of wall, with doors, separating them, and that's consistent with state regulation as well. For cultivation, the commission recommended that cultivation be allowed in the B3 if associated with a retail store, so making that a little bit more flexible as well. Oh, and then they were very interested in the idea that manufacturing of marijuana edibles is similar to a bakery, a commercial food production bakery, which is a conditional use in the B3 in the Anchorage Bowl. I think it's a little bit different in the Chief-Eagle River area. And so they recommended that a manufacturing facility that only manufactures edibles but doesn't do any extraction processes or other types of manufacturing be permitted in the B3 district, so that it would parallel bakeries.
Okay, now is the moment everybody's going to realize how green I am on this. Not literally. So when you're making edibles, is there a sense associated with it? Because I'm hearing from other businesses that are concerned about these industries coming in, especially when it's manufacturing anything. I mean, do we have voluminous amounts of odor that come when you're baking, the extracts or whatever you're baking into the edible? I think that would be, imagine a strip mall, right?
It would appear that neither of us are
I'm not
experts.
entirely sure. Does anybody know? Bruce might know too.
Bruce probably knows, but I just heard from someone in Washington, had been in Washington State and had taken a tour through a place that was making edibles. And they said it smelled just like a bakery to them.
Well, that's just how they.
Yeah, it makes me hungry.
For the good of the body, do you have anything to add to that, Mr. Schultz? It just smells like a bakery, or?
Only on a small scale, commercial scale, I can't really speak to it other than, it's not, the additives that are put into the products are relatively minor in volume. I think it's fair to say that a cultivation facility with a mature plant is going to be more of another problem by huge margin than
Thank you.
Yeah,
I will say that seems to be borne out by the regulations and statutes that we're looking at in other jurisdictions, which typically require some kind of odor control plan for the cultivation facility, but it's not a subject we've often addressed in the
I just add, in our experience, those of us that went to Colorado last year, that particular issue never came up that I recall. Whereas, as Bill says, odor with cultivation, and even, I probably have a sensitive nose, but going into just retail establishments, pretty significant odor right there in the store, not so much outside. You'd smell it outside in warehouse districts where they have the big cultivation plants going on. And I think in Denver at that time, they did not have odor control for the cultivation, whereas next door Aurora, a similar population, had a kind of a zero tolerance odor issue. But yeah, the particular one with the bakery, it never came up.
The Planning and Zoning Commission recommended removing the requirement for retail sales establishments to have a neighborhood responsibility plan. The reasons that they discussed were that this is not something that we require of any other legitimate business, and that they didn't feel that the proposal was significantly fleshed out enough to be clear as to what this was trying to achieve. And then the other significant one, which I mentioned, was removing the retail stores from the B1A and the B1B, the small neighborhood commercial districts. There were one or two other pretty minor amendments, just a catch in the section of code about premises where minors are not allowed, which is really focused on adult-oriented businesses, your strip clubs and that sort of thing, has a discussion about separation from protected land uses except for alcohol, and so they caught that we needed to add in there also marijuana, so because it's addressed in a different way, so they caught one or two things like that.
Anything to add, Mr. Olson?
I think it's probably most beneficial to start fielding questions at this point. That's a good overview.
Mr. Treen?
Eric, I got a question for you. Let's say we've got a strip club that doesn't serve alcohol, but we still have a marijuana retail store in there. Because we have some strip clubs that don't serve alcohol. We go after the under 21. So do they still have marijuana facility inside of it?
People under 21 can't enter a retail sales establishment. So they would have that problem, but other than that, there's nothing that would prevent those two things from being co-located.
Mr. Evans?
Were all the suggested changes that P&Z made incorporated into the S version?
Yes, we always do that.
So,
Anyone else? Mr. Flynn?
Yeah, well, first, I gave a grand disclosure at our last meeting, and at this point, it looks like that venture is not going to go forward. So my conflict is...
Is that good or bad?
Your conflict got up and left.
It got up and left. But it was an educational process for me working through this. And I think these maps are very instructional for all of us to look at. The way the state regulatory process has been promulgated has created inordinate challenges for this industry to actually get established. And in the competition is the black market, the existing market. And I was surprised by how many people approached me after my disclosure and said, boy, if you can get something up and running, I'd love to be your customer. People I would not have expected. And so I think we want to be very measured in how we move forward on the exclusionary zones, granted being very thoughtful towards neighborhoods and fair to them, because if we are excessive, then the existing structure, which is quite robust, remains in place. And I don't think that's in our best interests. So I just offer that as a thought. I haven't had enough time to go through this to make the decisions as to where I think things should be added or subtracted, but I think that's worthy of consideration as we proceed.
Mr. Massey?
Thank you, and I just want to put on the record, I did not approach Mr. Flynn to be one of those. No, but.
No one in this body did, so.
I have some questions, one for Erica, one for Bill. Okay, first one with Erica. When we're talking about adding in, the changes for I-1, B3, and I-2 that P&Z are proposing, can you give us, by the next work session, just a rough map idea of what areas of town? I'm thinking of Abbott Loop, over by Fred Meyer, and I'm wondering if those are the areas that would be pulled in to allow manufacturing and retail in those areas where maybe before they wouldn't be. Can you just do you get what I'm saying? I just want an idea of by pulling those in and allowing retail and cultivation in those versus the original version. How many more properties are we pulling in and in what locations?
Okay, so are you looking for number of properties, or are you looking for acreage?
I'm looking for specifically, if I can look on the map and say, okay, see this whole corridor before it would have been excluded and now it's included. Just a general idea, because I'm trying to think in my mind, especially right here within the bowl area, what properties are now being pulled in to be eligible for this industry, provided they have property owners that are willing to provide it. But I'm just curious to see, because what I'm thinking is what existing neighborhoods, buildings, businesses are now going to be potentially impacted with this new neighbor. And if, you don't know unless you ask. So just would give me some context. And then, Bill, for when we're having a discussion of the federal drug zone and the state drug zone, and we've had a lot of discussion of the Cole memo, and I don't have it memorized, I haven't even looked at it in a few months, but if we deviate from federal zone, would that put us at any risk with staying in line with the very loose guidance that the federal government has given us thus far?
So, I welcome that question, because I think this is going to get a lot of attention, whether the 500 feet is the way to go, whether 1,000 feet is the way to go, or required by federal law. Here's how I would pitch that. The rules of this whole game now have been set largely by the guidance that's been issued by the Department of Justice. There are actually 4 memos. There's an Ogden memo in 2009, there's a first full memo in 2011, there was another full memo in 2013, and then the fourth memo. In any event, here's what the Cole memo from 2013 actually says. It says, traditionally, the states and the federal government have policed this area cooperatively. And we understand that the states are now experimenting, and some different states are now allowing recreational use on a legalized scale. The federal government and the Cole memo is signaling to us that it will allow those experiments to continue so long as certain federal enforcement priorities are protected. And the first of those federal enforcement priorities is preventing the distribution of marijuana to minors. The Cole memo on page 2, 2013, has a footnote, which reads, these enforcement priorities are listed in general terms. Each encompasses a variety of conduct that may merit civil or criminal enforcement under the Controlled Substances Act. By way of example only, the Department's interest in preventing the distribution of marijuana to minors would call for enforcement not just when an individual or an entity sells or transfers marijuana to a minor, but also when marijuana trafficking takes place near an area associated with minors. So what do we make sense of that? Is there a clear answer, 500 feet, 1,000 feet? It's not in black and white in the Cole memo, but we then say, what is the federal government trying to signal to us? There is a federal drug-free school zones act that does require enhanced penalties if anyone is doing any drug sales to minors or not to minors within 1,000 feet of school. Every other jurisdiction that has looked at this question, Colorado, Washington, Oregon, has said, we are going to keep these things 1,000 feet away from schools. The State Marijuana Control Board adopted a 500-foot rule, in part because the state's drug-free school zone is only 500 feet. If challenged on that, I think there are places in the state, like Kansas, the Southeast, others, who say, we have to go less than the federal drug-free school zone, because if the whole notion is that by legalizing this industry and regulating it in the state, we can actually better protect these federal enforcement priorities. We're going to keep it out of the hands of minors, because it will all be happening in stores where people are checking IDs. But we have to go less than 500 feet, because if you give us a 1,000-foot buffer, there will literally be no place for illegal sales to occur within our jurisdiction. That is not the case in Anchorage. We do not have that story to tell. The other piece of the Cole memo to flag for you is that the Cole memo does say if state enforcement efforts are not sufficiently robust to protect against the harms of interest to the federal government may seek to challenge the regulatory structure itself, in addition to continuing to bring individual enforcement actions, including criminal prosecutions focused on those harms. So there's some sense that the Cole memo is saying, if we don't sufficiently protect these federal enforcement priorities, we may come after you and say, municipality, what are you doing? I don't know if that's a high risk, I probably think it's pretty low risk. But the final point I do want to make is, we have some sense that the area of interest to the federal government is this 1,000-foot buffer from Colorado experience. So here I can point you, and members of the audience, to a Denver Post article from January 12, 2012, titled, Feds, Colorado Medical Marijuana Dispensaries Within 1,000 Feet of a School Must Close. And at that time, January 12, 2012, after the first Cole memo, before the most recent Cole memo, every medical marijuana dispensary within 1,000 feet of schools got a letter that says, you are legal and you must shut down, and there are enhanced federal penalties within 1,000 feet. Those letters could have been sent to the people who were further away than 1,000 feet of schools, but those guys didn't get the letter. So what we're trying to prevent is any action from the federal government saying, municipality, what are you doing? And trying to prevent leading marijuana establishments down the primrose path where they too may receive a letter like this from the federal government and say, we license you at 750 feet, but the federal government's saying you can't do it. Can I guarantee that 1,000 feet is the minimum requirement? No. Can I guarantee that we say 500 feet, we won't be able to get away with it? No. But our best guess from reading all these tea leaves, that the safer, certainly the more conservative, safer choice is 1,000 feet, and that's what we put in this draft to start with.
Well, and you dovetailed nicely into my second point. Actually, you totally covered it. Because we have these very, and some would say not very direct signals, but I'd say that's a pretty direct signal, especially when they're targeting people within 1,000 feet. If we deviate and we don't actually follow the Cole memo or the signals therein, it is opening up not only the municipality for exposure, but anybody who's operating a business within that area. I just, personally I think you're right on this one, and I think there's no reason to go less than 1,000 feet. But that's
Anything else,
nothing.
Mr. Adams?
Just kind of following up on what Mr. Falsey was saying, and I appreciate that explanation of the 1,000 feet there. Are there any areas that we are expanding the protection zone more than the state has that aren't due to that rationale of the 1,000 foot? Is there any other areas where we're increasing protection?
No, the what's written in the S version is the combination of the state regs and the federal drug-free zone.
Okay. Thank you.
Yes, that's fine. Let's go ahead.
I was just going to add a couple things on the Cole memo that, again, buttress the idea it's better to err on the side of being cautious. One is that the Cole memo is titled Guidance Regarding Marijuana Enforcement. It's not policy. It's guidance to individual U.S. attorneys in the various states. They actually can choose to be more strictly enforcing if they want. The U.S. Attorney in Colorado, John Walsh, who issued the letters that Bill talked about and is still the U.S. Attorney, for example, in 2013, there was a follow-up memo basically saying, we mean this about concern about kids. I looked at their website recently. They had several news releases, all from 2015, highlighting prosecutions that relate directly to the guidance in the Cole memo, not with regard to minors, but with regard to marijuana being taken out of state, which is one of the things they talk about, for sales, being on federal property, using the U.S. mail. All that to say, they seem to be very serious about their guidance. And apparently Eric Holder, when he was Attorney General, and that's actually when this got issued, the Cole memo by a Deputy Attorney General, he was arguably softer on the idea of marijuana being legal. Loretta Lynch testified at her confirmation hearings, the new Attorney General, that she was opposed to marijuana legalization. So again, all that to say, At any time, they can choose to become even more strict, because this is just guidance, it's not statute, it's not law.
Thank you, Mr. Shirley. Mr. Crane.
No question for you. Did Colorado or Washington go with 500 feet or 1,000?
1,000.
And so our state chose to go 500 versus 1,000. So if we, as an assembly, go 1,000, is that going to run across the state of Alaska from your perspective?
Well, it doesn't have a legal conflict. We're allowed to regulate context and manner of marijuana establishments more objectively than the state does. Practically, it's a difference. Under the state regulations, they would prevent you at 600 feet. We would not. So there's a practical difference, but it's not a legal conflict.
Petersburg's petition for 200 feet.
Mr. Peterson.
Thank you, and just to follow up on that, I would think there might be some people that would want to open a certain location and find that if it wasn't legal because it wasn't within the correct separation district, but it would be legal within 500, that it's not legal within 1,000, that might want to take legal action to try to get their opportunity that would be legal by state law that all of a sudden was not legal by municipal ordinance. And are we in a situation where they might be able to win a case like that, or drag it on and end up spending a lot of resources trying to defend our position on that?
So I have to say that I had someone whispering my ear for half of that, but I believe the answer to that is no. I cannot imagine a situation in which someone could say, I wish to be able to operate in a way which is not consistent with municipal code title 21. I don't think there is a plausible cause of action where if we say you're not going to issue a special land use permit for marijuana greater than 1,000, within 1,000 feet of the school district, someone can say I have an entitlement to operate in that manner.
Okay, just wanted to throw it out there.
One last question.
I'll catch up with you, Mr. Ms. Dembowski.
Thank you, Mr. Chair. I just wanted to, I think it will help the members if we could have the Department of Law furnish us with all 4 of the memos that they're relying on before the next work session, just so we can kind of refamiliarize ourselves with that.
And this is a work session. You can ask as many questions as you want. Mr. Evans?
Just to get a bit parochial for a minute, Ms. McConnell, with respect to Gerda, we didn't have the maps up here. It's my understanding that that may be an area where, like Mr. Falsey was talking about, if we have the 1,000-foot barrier, it would effectively preclude any real possibility of any businesses in any known privately held commercial or industrial zone.
There is available commercial land, but it's in an area that is undeveloped with infrastructure at this time. Here, and actually there's also available down in the old town site by the highway. But the area...
Sunk in 1964?
No, that's on this side. This is, but there is, the city is working on building Egloff Drive here, but the extension down into this southern area of the new town site is not, as far as I know, nobody's planning on constructing that at this time.
And you mentioned, Bill, that others, I think you said that other locations have at least requested leave from the 1,000-foot requirement because of the precluding available land. Are we able to do that for, like, Girdwood, not taking Anchorage as a whole, but if that 1,000-foot limitation made it impractical in Girdwood, would we be able to seek a legitimate exemption for a certain area like that?
And I should clarify, I'm not aware of anyone who has ever gone to the federal government and asked for an exemption. What I'm aware of is in the state marijuana control board process, there was testimony from a variety of different communities, and now, as Representative Flynn said, petitions from some communities saying make it smaller. We can always ask. We could roll the dice and do it. I think that's the best answer I can give you. And I guess one thing to point out actually is that we came to this recommendation. We can work from the map backwards. We worked towards the map. So we were trying to find what are the separation distances that we can recommend to you that we think we are safest, and then we let the chips fall where they may and saw what that did to the map. So want to give the Assembly and the audience members some confidence that we weren't working backwards with some notion of what the maps should look like. We arrived at the maps from these first principles, not the other way.
Erica, on page 12 of 30, item 6, it says a housing facility owned by a public housing authority. How do you define what that is, and how many of those entities do we have here?
I talked to Mark Romick at the Alaska Housing Finance Corporation, and he said that they are the only public housing authority in the state. And he sent me a list of their facilities, and there were a lot of them, but I don't have that on me today. I can get that for
You
you.
can get that from me, I appreciate it. I'm also concerned about anything else involved in that category, like
They-
assisted living, housing, or something.
They were very firm that they were the only public, I mean, they had me send them the federal language, and they were very
My
clear that they
cabin's
were the
outside
only
these
public
living
housing authority in the state.
Awesome.
If you give
But it's
me
not
that-
commercially zoned.
Thank
We
you.
can change that. Spot zone.
Mr. Chairman, back to the Girdwood situation, now, I don't represent that district, but I think we have to be careful that the people in Girdwood don't feel like they're getting treated like second-class citizens, that they don't have the opportunity to purchase legalized marijuana. And I was wondering,
We've done the first right there.
would it be possible, or do you think, or where in this document would an amendment go that would lower it to 500 feet for people that live in Girdwood, or what would some designated geographic location somewhere close to that?
We would make amendments to this section 2105.055A2 that starts on page 12, where it discusses separation from protected land uses. If there was a kind of a carve out for Girdwood, we would put it in that section.
Okay, thank you.
We do that for both Girdwood and for GW
No,
Road.
thank you.
Mr. Steele?
You can have it.
Yeah, I'm concerned a little bit about assisted living. The state, and I think Secti is trying to encourage dispersal of people into renovations across the city, not having big development, but take people that have an opportunity to into different housing. Within that, because it's state's paying part of the town, does that mean that precludes, does that pop up as a exclusionary area, or an area where you can't place something? What happens if there's something already there, and so on and so on?
I'll have to do a little bit more research to confirm this, but it's my understanding that just because the state is providing vouchers, that doesn't mean that it is a housing facility owned by a public housing authority. So I would think that that would not.
It's not owned by you, but it certainly is, statement is going into it.
Sure, but that's not the qualification within the federal language. So I mean, I can confirm that, but that my understanding is that would really.
Will these coming out be placed somewhere?
Yeah, I don't think that would have an impact.
Veteran assistance, assisted living.
Mr. Belsky?
Thank you. Just talking about the Girdwood issue, I don't know, Mr. Evans, maybe they won't want marijuana in Girdwood.
They've never heard of it.
Obviously, a big part. But two things for Mr. Falsey. When we're considering a potential carve out for certain areas of town, and this might be something that you just ponder and come back to this. But one is if we make a carve out for a community that does have any amount of land or some amount of land, you might have to think about that. If we make a carve out for that community that does have potential for land being available, what risk do we have with the other areas of town potentially having, issues or a case to be made that, you know what, if this area of town has a carve out, well, this area should too, and this area you know, those are some of the things maybe you can kind of ponder and think about. I'm not sure.
Yeah, I'm not trying to give you a firm answer here. Certainly someone can make a claim that we're violating some kind of equal protection, that we're not treating similarly situated people similarly, or that we're being arbitrary and capricious. On the other hand, you know, all of these zoning decisions are very fact-specific and tied to the realities on the ground in the various zones. So I don't think there is a well-stated case to say, why does Girdwood have its own zoning districts, which are different in kind from every other zoning district in Anchorage, which is the case now. Why does the river have different kinds of zones that are not the zones in Anchorage? So I suspect that we would prevail if we had different rules in certain areas of town for others, but
And maybe another place where we can deal with Girdwood too is within Chapter 9. I know that's not quite finished yet, but maybe that's, I mean, I know in Chapter 10, you know, we have our own stuff, so maybe that's another place where we can tighten some things up down there. I'm not sure, but for those members who thought Anchorage maybe something like that.
Mr. Train?
Erica, getting back to where it can be, where the Francis Shelter, Rescue Nation, we know there are people that live there, various substance abuse problems, the epidemic of spice there. Would they be a protected area within 1,000 feet of that facility? Or could
No.
somebody could open up if they had an area right near there?
Mr. Steele?
Yeah, I'm thinking about a section of road on Fireweed Lane. You've got a drug treatment program. I'm not sure if that's a part of that or not. You've got a private Catholic school. You've got an elementary school. You've got a high school / middle school. You know, so for a good chunk of Fireweed Lane, you may have daycare along there. A good chunk of Fireweed Lane is off limits.
All of it.
Is it?
All of it.
Well, that's a good chunk. Anyway, and then you're certainly limiting where other things can go. If you have an establishment that was legal when it was put in, then other people making choices for those other types of activities, the daycare, so on and so forth, would they be restricted from locating after the fact with no zoning?
No. And so a school, a religious assembly, anything sort of that sort of thing, going in after the establishment of the marijuana business would not be restricted.
Yeah.
And the marijuana business would be grandfathered in that location as long as their license is maintained.
Yeah.
Okay.
Mr. Mouse?
Thank you. Okay, so this discussion about homeless shelters kind of brought me back to the list that P&C amended on page 13 of 33, and one of them is parks. So if we're thinking about places where kids are and parks and all that kind of stuff, is parks outside that realm that the federal government and the state think about? So, sorry, no, you know where I'm going. Yeah.
So the federal government highlighted playgrounds and the state highlighted athletic fields. So while parks was removed, playgrounds and athletic fields were kind of kept in. So what our GIS staff had to do is we had to get a list from the Department of Parks and Recreation about where all of their playgrounds and athletic fields are, and then they had to go in and digitize around each playground and each athletic field to create the buffer from just those, not the entire dedicated park. So you'll see that playgrounds are 2A B on page 12 in the 1,000-foot buffer because that's mentioned in the federal legislation. And then athletic fields are 2B V under the 500 feet because that's part of what the state considers to be a recreation or youth center.
So we don't have any conflict there with federal government thinking that a recreational youth center or park is a place where kids are? Is that what we're saying? Is the federal government? I'm trying to figure.
The federal government specifically talks about all the different types of schools, public and private schools, playground, housing facility owned by a public housing authority, public or private youth center, public swimming pool, or video arcade facility. And I don't have the definitions at my fingertips, but their youth center definition was pretty clear. It was an indoor thing.
So just to follow up, I'm thinking of Loretta French Park. Are you familiar?
Somewhat.
So we have obviously athletic fields, baseball fields, but now, and we also have playground equipment out there, swings and jungle gyms, and we also have an outdoor skating park. So to me, as I think about it, yes, it's athletic fields, but it's also a playground, but it's classified as a park. So where's Loretta French going to fall in this?
So ideally, and I haven't looked at the map over there, but that the buffer would start, you would outline the playgrounds, the skate park, the athletic field, we would outline those things, and the buffer would start from there, not from the edge of the park itself.
Okay, that's helpful. It's a pretty big park. Yeah, thanks.
Anyone else? If not, we've got a half hour and we've got audience participation. So this is your opportunity to share your thoughts with the body. Anyone? Mr. Schultz?
Thank you, Mr. Hall. A couple of questions and observations. First, in the previous iteration of this ordinance, I think that there was a difference in the measurement criteria whereby the state measured the offset distance based on the shortest path to travel. I thought that in an earlier form of this ordinance, it changed the form of measurement in Anchorage was as the crow flies, from the edge of property to edge of property. Did that change or did I misunderstand that?
All the drafts have always used the state measurement, which is shortest pedestrian route. We did propose an amendment before the Planning and Zoning Commission to do property line, but they did not accept that amendment.
Oh, okay, so my misunderstood that process. An observation I would offer, the discussion about 500 feet versus 1,000 feet is an interesting one. I would offer that the three states that precede this legalization, Colorado, Washington, and Oregon, they all had established 1,000-foot preschool zones in statute. Alaska has the 500-foot, as the policy has sort of alluded to. But I think that's significant in that they already had that proceeding that was established in ordinance statute. The other thing I would offer is much of this discussion has to do with the trafficking of marijuana to minors, which everybody would agree is a bad thing. However, that sort of implies a transaction, a retail transaction, which makes sense in the context of a retail facility, but I don't see how it would reasonably apply to a cultivation facility, a vetting facility, or a processing facility. And to be honest, those are the most problematic facility types from a land use perspective from our side. So I would offer that it might be worth looking at separating the two, saying, okay, we are going to go with retail stores, retail transactions differently than these other facilities, which are very, very different both in their aesthetic and their function. That's all I thought.
Anyone else? Chris?
Yeah, Mr. Hall, Chris Constant. As you heard, the Planning and Zoning Commission amended the document to remove the neighborhood responsibility plan concept. You heard two reasons why. One is because no other businesses are required to do this, and second, because it wasn't a clearly defined function. And so, working with the group of the Cannabis Business Association, members of Fairview Community Council worked hard to kind of define more clearly what the concept would be under law. And kind of communicated with all the members of the Assembly, and I know that some of you received that communication. And I would suggest that after speaking with the chair of Planning and Zoning, that they were right to remove it from the Title 21 because it's a land use issues, and this isn't the land use issue. The neighborhood responsibility plan more logically falls under the Title 10, the licensing issue, because the purpose of the neighborhood responsibility plan, as we've defined it, is to create a vehicle of communication between potential applicants and communities, so that there is a structured way that the businesses and the communities can communicate to avoid problems and to mitigate problems should they arise. The Fairview Community Council, as all of you are well aware, last year struggled on a 2.5-year Goliath process to shut down an operator in the neighborhood of a package store that just failed at being a decent member of the community. And that process involved the community working with both package stores in the neighborhood to establish ways we're going to communicate and benchmarks of how you should run a business and how neighbors should be interacting. That process made clear that one of those package stores was able to function as a good business and a meaningful participant in the neighborhood. One wasn't. And that business, because of your work, our work, and the state doesn't exist anymore. Now, people had a lot of fear initially about what is this idea of a neighborhood responsibility plan. And what we came to understand in our process is not a document where the community council extorts from the operator, the potential operator, level of behavior, you will do this, you will do that. But rather, it's an agreement between both parties on how we will interact with each other. It's actually a pretty simple tool that we have proposed with some basic information that we would like to see included. One is the clear establishment of a point of contact and the having of that point of contact on the outside of the business so that a community member has concern can communicate with the owner of that store, the person identified as the contact. Second is to establish a preferred method of communication for the community council to the business and for the business to the community council. Third, what's that?
Can you repeat that?
Yeah, it's to establish a preferred method of communication between the community council and the business and between the business and the community council. So we agree, this is how we will talk to each other when it's time to have hearings. Next, provide a dispute resolution process internally. How problems, issues, and disputes brought forward by neighbors will be addressed, such as meetings with the complainant or discussions at the community council and things of that nature. Just participating in the process. Next, and this one kind of is similar to A, is establish 2 individuals who can formally speak for the business at a community council meeting. The reason we have 2 is because the primary will often want to take a vacation and can't always be present when an issue might arise. So our council is flexible with our business representatives. We like to have 2 people. They only get 1 vote, but that way, if somebody's out of town, we still have a way to communicate. And then lastly, identify frequency of attending our process and being part of the neighborhood. And what came out of our last meeting and the consensus was in the first year of operation, there were a new license once every quarter, and then thereafter twice a year, just to be involved in hearing what the community concerns are. Now, the thing that we left out in the communication,
Chris, I need to.
I'm just about done, is a conflict resolution process, right? Because what I have seen is clearly there are communities that are saying, no, not just no, hell no. And in fact, one of them last night proposed creating a red light district in Fairview, which is not something we would be appreciative of. But that would involve either a member of the assembly or the ombudsman hearing when a concern isn't being met or a council is just saying no. And so we would like to see the neighborhood responsibility plan added back into this tool, probably under licensing because it's reviewed with the license application on a biannual basis.
Thank you. Mr. Peters.
Thank you, Mr. Chairman. And I understand where you're coming from, Chris. I just think that opens up an equal opportunity lawsuit from someone who says, well, the guy with the liquor license down the street, he doesn't need to do this. And now I got to come up with some neighborhood responsibility plan. I don't know. I think there could be a problem there. Just thought I'd throw that point out. Thank you, sir.
Thank you. Yes. The young lady.
I just had a couple of questions. First off, commercial horticulture is by right approved in certain lots in Eagle River residential, and also it is by right allowed in B3 areas. But with the proposed regulations ahead of us, the zoning for B3 would require cultivation to also have retail attached, where a cultivation center would generally not have any advertising or customers, or no one would really know it was there. But if you require it to add a retail, everyone will have to know it's there because of the advertising that's there. So it seems to me like in areas like Chukiak, Eagle River, where there's no industrial lots allowed for marijuana right now, there's only B3, whereas you may have had one resident or one retail establishment try to open, you may now have somewhere around 10 because there's B3 lots available, but you have to have retail to grow on them. So my question is, how are you taking commercial horticulture and changing the definition to an industrial horticulture?
Commercial horticulture for marijuana is kind of by nature different from other types of commercial horticulture just because of you're not allowed to have it in a location where it can be visible to the public. It's by nature going to be, because of these restrictions, it's going to be an industrial use. It's going to be in warehouses. There's not going to be windows. There's going to be nothing about it that isn't really an industrial type of use. And so our proposal originally was to have it only in industrial districts. But again, as Planning and Zoning Commission recommended, if it has an associated retail store, they felt it was then appropriate to put it into a commercial district. But ultimately, the perception from the staff end was that it's different from other types of horticulture due to the nature of what you're actually growing at.
So
Yes.
would it be safe to say that the commercial horticulture being done in B3 with attached retail would look exactly the same as commercial horticulture done in B3 without retail, other than it is more advertised as such?
I'm sorry, could you repeat that?
The B3 zoning,
Yeah.
a commercial horticulture attached to, or a commercial marijuana attached to a retail is going to look exactly the same as commercial marijuana attached or not attached to a retail. Except it would be more advertised.
Well, it'll have the nature of a business that the public comes to and
Would there be a size restriction for B3 cultivation? So it could be a 10,000 square foot cultivation center with a 2 square foot door opening with a retail, and it would look exactly the same.
But the Planning and Zoning Commission recommended.
I guess our response to you right now on that one is yet to be determined. It's a good question.
And also with that, there's no overlapping of businesses allowed on a premise, according to the proposal. How would you have B3 growth and retail with no overlapping of licenses?
So the state requires that these different facilities be separated with a wall. And so essentially you have, it could be in one building as long as there's a wall separating these. Your licensed premises for the store would be on one side of that wall, and your licensed premises for the cultivation would be on the other side.
Yes, you mentioned.
First, I want to make a correction, and I heard this again last night. There is industrial land in Chugach, Eagle River, and Birchwood. But what yes, I just double checked the map. There's multiple. But one thing that I know this is, I apologize in advance. This could be tough for the planning department, so Chris, don't shoot me. But it would be helpful in my district. There's a number of industrial lands that have special limitations. Can you guys give me a rundown on what those limitations are so I can understand? Because there is a significant inventory of industrial land in Chugach, Eagle River, and Birchwood. But I want to understand what those limitations are so we understand if, in fact, the narrative that's being pitched that there's no industrial land, if there's anything to it. Because maybe what's being meant is there's no industrial land that they could use. But that would be helpful for me to understand. Thank you.
Mr. Peterson.
That kind of sort of leads me back into a question that we talked about, seems like at least 6 months ago. And that's the greenhouse question. Until this coming May, or whenever everything gets finalized, marijuana has been an illegal plant. But come May, it's going to be a legal plant. Now, it's a controlled legal plant, but it's still legal. And so what would happen if some place that had been a greenhouse for decades and been growing tomatoes or flowers or trees or whatever, and they went out of business and all of a sudden got bought by an outfit who wanted to grow marijuana? Are we in a situation where they're going to be able to legally eventually force us to give them a license? Just wondering.
I think there are a few, and possibly no situations where anyone could force us to give them a license. But I think to the general question of whether an existing greenhouse can be converted to a marijuana grow, the answer is depends. If they can satisfy the Title 21 dual licensing requirements, yes. There were provisions on the ballot measure itself. It says marijuana plants should be cultivated in a location where the plants are not subject to public view without the use of binoculars, aircraft, or other optical aids. So that would be a restriction we have to comply with too in your greenhouse, but I think it's a possibility.
Okay, thank you.
Mr. Klein?
Yeah, Erica, prior to our next discussion, could you check in and see what, if you don't know already, what the railroad's policy is going to be on utilizing their land?
You can't use airport property or
Railroad.
either. And Eagle River should get industrial, Equipment Inc. and railroad. And airport.
Yeah, I'll get you in just one moment. Also, I think it's really crucial that we look into this young lady's question about what size of road can give in the retail and in a business zoning. 10,000-foot grill with a 300 square foot retail, it's, my guess would be marginal at best. So it appears to me that with the P&Z saying you should give consideration to that, it's going to have to be pretty hard consideration given to what we're talking about in size. Thank you. Yes, sir.
A couple of things. I've reached out to the railroad, and actually, if they're in compliance with state, the railroad is actually okay with it. I agree with the airport. I've reached out to them too, and it has to be airport-related business to be on airport ground. Kind of out there. One thing I want to touch on what Bruce said with the measurement is it makes a huge difference on how it's measured. A property could be 500 feet or 700 feet away from the school, or it could be 3,000 feet of pedestrian route. So that's crucial for you guys to kind of keep that in mind. Second thing, from an industry perspective, as far as the full memorandum, it's relating to trafficking with minors. I agree with like retail stores on that, but I don't agree with like cultivation or manufacturing. Cultivation, we have to have a manifest where we actually have to track that to the store, where we actually sell it at the store. We're not making sales at a cultivation facility. So we're not actually trafficking to minors or making that sale within the district. So that sale is actually going to be at a retail store where we drop off the marijuana. So as a cultivator, as an industry perspective, I don't see that as trafficking to minors on a cultivation facility or a product manufacturing facility. To me, that is directly related to retail sales. So just kind of want to throw that out there as far as perspective. But as far as property and hunting, I've scoured Anchorage. It is very difficult if we go as property line to property line, but it makes it much more open if we are pedestrian around. So, thank you.
Mr. Mouse.
Mr. Halsey, how does the federal government measure their 1,000 feet? Somebody may have said it, and I may have missed it.
I think we decided it was as the crow flies. The statute.
So that would be the pedestrian path.
No,
As the crow flies, I don't know what that means.
Point to point.
You literally look at the
Property
map
line.
from bird's eye view and you say point A to point B, and you don't have to figure out if you can literally walk. There's a wall that you have to walk 1,000 feet around, that doesn't
So
matter.
basically, you put your pin in the middle and you draw your line, that's 1,000 feet. And the pin in the middle is the building.
So it's how the crow flies.
I think it's for the property line of the school.
I'm still trying to get a specific answer.
So our change is that it's from the property line of the school to where the drug transaction takes place, direct line. So if the school is separated from the street by a large lawn, go all the way to the end of the lawn, you draw a straight line to the drug transaction, and you ignore the fact that you got to cross a river and go around a wall.
So, property.
Yeah.
Property line to the drug transaction.
Property line of the school out 1,000 feet.
Yeah, that's where I was going for, thank you.
You and I are 20 feet apart. To walk to see you, I have to go 25 feet.
Okay, I get that. No, I'm trying to understand because the way we've been discussing it has been by pedestrian path or by property line. So that's why I was trying to get the correct answer. Thank you.
Mr. Evans.
Just to follow up on what Bill was saying, is the definition itself drug transaction? Is that what triggers? And I guess it follows up on what that gentleman was saying about the cultivation facility not having transactions in that sense.
Right. So the answer to that question is we will be able to defend whatever position the Assembly wants to take. The Controlled Substances Act says any person who violates this by distributing, possessing with the intent to distribute, or manufacturing a controlled substance in or on or within 1,000 feet of any real property comprising of the school, etc. And the Cole memo uses slightly different language. It says in that footnote that I previously read that we care about the enforcement, not just when an individual or entity sells or transfers marijuana to a minor, but also when marijuana trafficking takes place near an area associated with minors. So you make the call, what counts as trafficking, and does that incorporate the full distributing, possession, and manufacturing of the Controlled Substance Act, or something less? Happy to defend the Assembly's choice with everything.
Okay, I've got time for a couple more questions, and we get a short break. Yes, you're in the queue.
Hi. So, good afternoon, everybody. The first thing that I wanted to talk about is about the planning and zoning commission and issues that were brought up about B3. The problems that they had was they didn't want pedestrians to walk by the warehouses with no windows. And I just want to say that those warehouses are already there. So these warehouses aren't being built, they're already there, and there's some that are available that will make this industry more viable. I agree with what Jessica said about the retail in the front of the cultivation facility. Us as a group that are planning on cultivating, we don't want the public to have access. We don't want anybody to know that we're there. The neighborhood don't know that we're there for responsibility, but we want to be as discreet as possible for security. So as an industry representative, I just want to let you guys know that. Also, the B2A limits quite a few properties in downtown. So we want to think about that for our tourists. So definitely take a look at that. Also, I know you guys say there's a lot of industrial property available, or there is a lot of industrial property in Anchorage, and Amy mentioned in Shukiak, but we're talking about availability here. Not only are there not a lot of industrial properties available, some of them that are available, the owners have bank loans on them, and the bank won't allow them to sublease out to marijuana cultivators. So that's something to really take into consideration. Also, during the first planning and zoning, when we made public comment that daycare went into an industrial zone. So that limited that whole industrial zone because the daycare went in before we even started licensing. So it's just something to consider when you're looking at the planning and zoning. Definitely consider the industry. Talk to any of us. We would be happy to talk to any of you guys if you guys have questions. A lot of people are concerned with the industry and we'd love to be able to
The gentleman with the blue cap.
It is or it isn't? And right now it is.
So we work to make it succeed, we work to make it fail.
Yeah.
Right. But if there's, I'm of the same mind, so whatever you want to do.
I would say my answer as one assembly member is yes. And actually, as you were talking, there was a question I had down to follow up with Department of Law. So this, I assume, will be a big discussion next week at our work session. We're just trying to vet all issues and options. So I would say nothing's off the table.
We got a lot of hands popping. I'm not going to get to all of
If
them.
you go by the crow flies, you're dooming this industry.
Comment taken. So this young lady wanted to ask a question. So
I was just curious, is there going to be the 1,000-foot requirement between any type of cannabis businesses? So we can actually, if there's an area where there may be multiple facilities, and that's something that we don't need to worry about then.
That hasn't been a discussion. There's nothing proposed.
I'll try to be brief. With regard to this method of measurement, if you consider a school on one side of Seward Highway and industrial property on the other side, the method of measurement makes a huge difference. And I would ask you, is it reasonable to suppose that the presence of 6 lanes of highway is not an impediment to drug trafficking? I would also offer that all these retail, these drug-free school zones, the difference in criminal statutes that apply within and beyond those school zones apply to the illicit, illegal transactions. Okay, so I mean, it's fairly significant. Also, these retail stores are 21 and over. Anybody who goes into these stores is going to get checked for ID. That's a matter of the state process. They put their license at risk if they do that. Don't do that just as a bar would. And I would just emphasize, too, the point that's sort of been alluded to, but cultivators and processing facilities cannot sell directly to the public. That's a stipulation of their license. They can get their license suspended if somebody simply came to a cultivation facility and said, hey, can I 5 feet. So there's a huge difference in the commerce that's taking place. One final point, if I may. With the oil companies moving out and the infrastructure that supports them scaling back, there's a lot of warehouse space that's coming free. Do we really want to tell those property owners, no, we're going to keep you out of this viable industry just because of zoning considerations? I would ask you to consider that as well.
Want to let you do the last. I've actually got 1.5 minutes.
Sure. So I just want to thank you guys for all your hard work and making sure I just sent Mr. Craney an email that I got from Mark Romack that has that list of all the public housing locations. I thought that would be helpful. I got it from him unrelated to marijuana. Jan Wilson, I'm an attorney that works with the industry. And I would also note that I've been talking to a lot of industrial landowners, and the vacancy rent is 3 to 4% right now. So while hopefully maybe not hopefully, because that means our economy is going down, there may be some openings in some industrial spaces. So, a lot of people will rely on those industrial rents as their retirement. So I'm hoping that we can be consistent and maybe compromise and do, if we're going to do 1,000 feet, maybe compromise and do a pedestrian route. That would just be my final.
Can I ask one question?
Yes.
So I want to be very, very clear. There's no decisions made yet. But my comment, and I wrote it down, actually, so this is my comment for you to contemplate. Basically, I put follow up the Department of Law about the interpretation of how we measure 1,000 feet. If we say it's anything other than the way the federal government measures it, are we setting ourselves up to potentially be at risk, similar to those communities in the lower 48 that maybe have 500-foot rovers, or something number 2. But yeah, so if you can kind of see if you see any research on that, because if we say 1,000 but we calculate it differently, is that a problem? That's kind of where I was going.
I'm going to adjourn this meeting. We're actually reconvening in 5 minutes.